Yes. So in all these cases, the amendment has been challenged in the act. In all these cases.
सारे केसेस में नहीं है, कुछ केसेस में जो है अमेंडमेंट को इम्प्लीमेंट करने के लगे हैं, जो ओबीसी की तरफ से लगे हैं वो जो अमेंडमेंट है उसको इम्प्लीमेंटेशन के लगे हुए हैं। कुछ में जो है उसको चैलेंज किया गया है। जो
अच्छा, जो पहला वाला है उसमें चैलेंज किया गया।
हाँ, उसमें चैलेंज किया गया।
इसमें वैसे जो पहला वाला है 5901 लट से,
हाँ हाँ
इसमें जो पिटिशनर्स हैं,
हाँ।
ये पिटिशनर MBBS क्वालिफाइड हैं और PG एडमिशन में 27।
वेयर इज मिस्टर सांगी?
आई डोंट नो,
अच्छा, आ रहे, ठीक।
मैं काइंडली सी डॉक्टर, इसमें पिटिशन ही आप देखें, इसमें दिस पिटिशन इज ओनली फॉर।
तो जो एक्ट को चैलेंज किया गया है वो वाली पिटीशन ले लेते हैं।
जी, वो वाली पिटिशन है सर प्रत्युष द्विवेदी। ये है सर 38.3 है सर।
38.3
3
दीजिए।
इसमें ही रिप्लाई फाइल है स्टेट का सर, डिटेल्स।
ठीक, 38.3।
My lord,
38.3।
my lord, बेहतर ये होता कि कुछ क्वेश्चन ऑफ लॉ फ्रेम कर दिए जाते ताकि हम लोगों को भी बहस करने में सुविधा होती और योर लॉर्डशिप को भी इस पर ऑर्डर जजमेंट देने में सुविधा होती।
तो आप लोग सजेस्ट करिए।
मेरा सुझाव ये है कि कुछ क्वेश्चन ऑफ लॉ जो मेरे दिमाग में है और वो क्वेश्चन ऑफ लॉ बना दिया जाना चाहिए ताकि ये यहाँ से सुप्रीम कोर्ट तक काम आएंगे।
हाँ हाँ, बताइए ना। यस।
My lord,
सो एक कोई केस को तो लेना पड़ेगा ना डॉक्यूमेंट्स देखने के लिए। वो
जी
38.3 को ले रहे हैं।
जी,
38.3 में लेने में कोई ऑब्जेक्शन तो नहीं है?
नहीं, हमें कोई ऑब्जेक्शन नहीं, कोई भी केस लिया जा सकता है।
हाँ नहीं, हर केस को तो नहीं ले सकते एक साथ, एक को ही लेना पड़ेगा।
हाँ, जो मान्य न्यायालय की इच्छा हो।
तो 38.3 ठीक है?
जी ठीक है।
अच्छा ठीक, चलिए।
प्रत्युष द्विवेदी। इस केस में ही रिप्लाई फाइल है सर स्टेट का।
WP 16
जी,
552 16552
552 of 19। ठीक।
एक्चुअली दिस इज द लीड पिटिशन प्रत्युष द्विवेदी।
Yes,
Brad, may I just submit one thing?
yes.
On 17/7/2021,
हाँ,
my lords have said it in the order sheet that WP 5901
will be
is
the
a lead case.
All right, but since you are not there, so we.
My lord,
I said-
I was on my legs, my lord, so I rushed. So I'm just clarifying it that before my lord starts, it's my duty.
I have only taken out one of those cases where the statutory provision has been challenged.
My lord. So 5901 is a leading matter because the state has filed all the replies in that only. My lord. And that is Ashita Dubey, my lord. Item number 1.
उसमें भी challenged है.
My lord, virus has been challenged.
Right.
And first time, this honorable court heard me, and on 19/3/2019, written arguments have also been filed by me.
All right, then we take up 38 then first. 38 is 5901.
I'm extremely sorry that I was on my legs, my lord. My lord, I have prepared the written synopsis as well as the written arguments. I'm giving it to the reader, my lord. I request my learned friends, my lord, because I'll take some time. If they can have a comfortable sitting arrangement Because as far as COVID is concerned, COVID is exceeding all limits, my lord. So I'm just making a simple prayer to them. Give me space, and I'll finish it. I'll finish it very, very shortly.
चाहते हैं कि जो क्वेश्चन ऑफ लॉ कुछ फ्रेम कर ली जाए तो हम कुछ सुझाव क्वेश्चन ऑफ लॉ के लिए हम दे सकते हैं और जो क्वेश्चन ऑफ लॉ फ्रेम किया जाए उसके अनुकूल हम लोगों को आर्गुमेंट करना चाहिए। अगर आदेश हो तो मैं क्वेश्चन ऑफ लॉ में कुछ सुझाव दूँ।
इसकी एक कॉपी और दे दीजिए।
मतलब ज्योति, ये कॉपी होगी।
He's suggesting a few questions of law which can be answered.
My lord, in fact,
Now-
there is no question of law. I would like to apprise my lord, this is two bunch of petitions. In one bunch of petitions which I am representing, total 10 petitions I am representing. In those 10 petitions, the virus of 27% was challenged, and all those bunch matters are before my lords. Only except for one petition of mine, which is not a virus, because in that petition I have raised a point that as far as 14% OBC reservation is concerned, that's a valid reservation. So MPPSC should continue with the 14%. So only that petition of mine, out of the 10, there is no virus. Apart from that, in all the petitions, identical virus petitions have been there. Now the other bunches, which my learned friends are representing, my lord, which says that no, reservation should be 27%. So these are in a way totally opposite petition, but clubbed together because it is an OBC reservation matter. So as far as my matter is concerned, on 17.7, my lords have said it, my lord, I would like to read that particular order sheet. From there only I will start.
Yes.
So I again request, my lord, at the cost of repetition, that if my friends will sit down, it will be beneficial for all of us, my lord, because COVID has really taken a new turn, my lord. So my lord, I am coming directly to an interim order passed on 17/7/2021. On 13/7, I stand corrected. It is an interim order passed in this case. Written argument, fine. I'll give you the written argument. Just a minute.
निकालिए एक्ट निकालिए 94 में
Now, my lord, on 13/7, इनको एक copy दे दीजिए।
94 का एक्ट यस
Rameshwar ji ko. My lord, on 13/7, my lords have said it. First paragraph I would like to read. Under challenge in all these writ petition is the validity of Madhya Pradesh Lok Seva अनुसूचित जातियों, अनुसूचित जनजातियों एवं अन्य पिछड़ा वर्गों के लिए आरक्षण संशोधन अधिनियम 2019 promulgated on 8th March 2019. Now, my lord, this is
which order sheet
13/7/2021. Honorable Justice Rafiq, my lord, no? In 5901, my lord. July, my lord. So the first paragraph says, fourth line, my lord, promulgated on 8th March 2019, which later on became Madhya Pradesh Lok Seva Sanshoshan Adhiniyam 2019, as a result of which the reservation in favor of OBC categories has been raised from 14% to 27%, thereby the outer limit of reservation from 50% to 63%. Then para 2 says, this court, after hearing the learned counsel for the parties, passed an interim order in WP 5901 of 2019 on 31/1/2020, which has since then remained in operation. The operative part of the said order reads as under. Accordingly, after hearing the learned parties, it is directed, it shall be open for the PSC to go ahead with the selection process. However, the same shall not be finalized and no appointment shall be made without prior permission of the High Court. Now, my lord, I am skipping all these things, my lord. I am coming to the last paragraph. Para 7, page 5. Para 7 and 8, the last page. Accordingly, the IA number so-and-so stands disposed of. This court on 17/2/2021 required the learned counsel for the parties to file the WS and further directed the WP that WP number 5901/2021 shall be treated as a lead case, which the learned Advocate General submits, that the reply filed by the state in that case shall be adopted in other matters too. So twice my lords have said it, that this will be the lead case, and all the pleadings of the state government have been filed in this particular matter. So I am representing total 10 matters, including this particular petition, my lord. Now, my lord, as far as the virus point is concerned, my lord, as far as the facts is concerned, facts are very, very brief, because according to me, the matter is squarely covered not only by Indira Sahni, that is 1992 supplementary, but by Maratha reservation, which is now the latest judgment of the Honorable Supreme Court on this point. And on each and every point, whether it is a population ratio, whether it is a quantifiable data, whether it is the latest census, the Honorable Supreme Court has considered each and every point in detail, which I would like to read those paragraphs. But first, my lord, I would like to, Lord, the written arguments are before my lords. Now, my lord, the act is Lok Seva. This is, I am reading from MP Laws Manual, volume 21, my lord. The act says that this is Lok Seva, मध्य प्रदेश लोक सेवा अनुसूचित जातियों, अनुसूचित जनजातियों और अन्य पिछड़ा वर्गों के लिए आरक्षण अधिनियम 1994. This act says, my lord, as far as section 4 is concerned, page 227 of the manual, fixation of percentages for reservation of post and standard of evaluation. First, unless otherwise provided by or under this act, the posts reserved for the members of scheduled castes or scheduled tribes or other backward classes shall not be filled by the members who do not belong to such classes as tribes or classes as the case may be. 2. Subject to other provisions of this act, there shall be reserved for persons belonging to scheduled caste, scheduled tribe and other backward classes at the stage of direct recruitment, public service and posts. At the state level, the following percentage of vacancies arising in recruitment in class 1, 2, 3 and 4 posts are as follows. This is SC, ST, OBC. The percentage of reservation is risen, that is 16%, 20% and 14%. Now this has been amended by the government, first by way of an ordinance dated 8/3/2019, which is, I had filed Annexure P1, my lord. Sorry, my lord, Annexure P4. P4 at page 29. The ordinance of the government of Madhya Pradesh, which says,
What was amended?
it was amended,
Which section 4?
sections 3, my lord, subclause A, section 4, my lord, section 4. Here in the ordinance, it is 3, which says, धारा 4 का संशोधन. मूल अधिनियम की धारा 4 में उपधारा 2 में खंड 1 में एक उपखंड का में शब्द एवं अंक अन्य पिछड़ा वर्ग 14% के स्थान पर शब्द और अंक अन्य पिछड़े वर्ग 27% स्थापित किया जाए. उपखंड खा में शब्द और अंक अन्य पिछड़े वर्ग 14% के स्थान पर शब्द और अंक अन्य पिछड़े वर्ग में 27% स्थापित किया जाए.
All right, yes.
So,
All right, this is understood. No?
So-
Please come to the point.
yes, my lord. So this came on 8th of March. My lords heard me on 19th of March. This ordinance was stayed. Then, my lord, finally, the act came into force, my lord.
Where is that?
That is P6. By way of an amendment in the petition, page 48 and 49 are the relevant pages, my lord. Here the same thing was amended on 8th July 2019. Here again, they say, पैरा 2, my lord, धारा 4 का संशोधन. मध्य प्रदेश लोक सेवा अनुसूचित जातियां, अनुसूचित जनजाति एवं अन्य पिछड़े वर्गों के लिए आरक्षण अधिनियम 1994 की धारा 4 में उपधारा 2 में
All right,
खंड
okay.
1 में सो एंड सो. Now, my lord,
Class 1 to class 4 in all categories.
yes, my lord. Yes, my
It
lord.
was
Now, my lord,
increased from 14
yes,
to
my lord.
27.
Just, my lord, for a minute, I will show page 45, my lord, of my petition.
Yes.
Because the petition arises from the medical students who were appearing in pre-PG counseling, and through NEET examination, they got selected. The pre-PG rules 9th of March 2018, page 45. It says, Arakshan Pratijat, SC 16%, ST 20%, OBC 14%. So the now government brought the ordinance, and thereafter the act, and thereafter both the things by way of interim orders have been stayed by this honorable court. Now, my lord, as far as other petitions are concerned, my lord, they are mostly against MPPSC, because later on that I have mentioned in my written statements also, my lord, as well as my synopsis, that later on, my lord, because of the opinion of the then Advocate General, across the board, 27% OBC reservation was applied, except for those departments where there were specific interim orders, specifically medical education department, because so even this, because this matter was of the post graduation, even in MBBS counseling, 27% reservation came into effect in the state of Madhya Pradesh. But when matter was heard by the division bench immediately stayed it. So the counseling was conducted by the Director Medical Education only on the basis of 14%. And vis-a-vis MPPSC is concerned, MPPSC applied 27% in most of the results, my lord. So, but one petition, because I'll like to say, my lord, 20093 of 2000. This petition, my lord, of 2020, that is Om Prakash Patel versus State of Madhya Pradesh. In this petition, I have not challenged the virus, and I have raised a point only that as far as 14% OBC reservation is concerned, that's a valid reservation, and therefore the MPPSC should go ahead with that. So only that petition is an exception where the virus of the rule is not under challenge. Now, my lord, my respectful submission is that as far as Indira Sahni's judgment is concerned, that is 1992, supplementary. This is, I am reading from 1993 AIR, my lord. Supreme Court 477. Para 477 onwards, the matter travels, and the relevant paragraphs are para 810 and 811.
What
And-
is the first page?
Page is 477, my lord.
First page by the
First page is 477 of the AIR. Although I have given the citation of the supplementary, SCC supplementary also.
Yeah, 93.
Pardon, 1993. AIR 1993 Supreme Court 477. The 9 judges judgment of Indira Sahni versus Union of India. It starts from page number 477 and it ends up.
Which are the relevant paras?
Relevant paragraph is 810 and 811. And this particular paragraph has been clarified. You can, my lord, I can say that 810 and 811 has been discussed again and again by the Honorable Supreme Court in Maratha reservation as well as in Nagraj. But Maratha reservation covers each and everything vis-a-vis my point is concerned, my lord. So first of all, I would like to read, my lord, the Maratha reservation matter, because that covers each and everything vis-a-vis Indira Sahni is concerned. So I am coming, my lord, directly. My lord, Maratha reservation, which is a matter which is known as Jayashri. This is page 1 of 2021, volume 8 SCC, page 1. I have given to my lords the relevant paragraphs, which I will be reading, my lord, and which covers each and everything as far as Indira Sahni, as far as my matter is concerned. Jayashri Lakshman Rao Patil versus State of Maharashtra. Justice Ashok Bhushan speaking for himself and for others. Now, my lord, before this particular judgment, I would like to cite one small judgment, division bench of this honorable court, way back in 2003, 4 MPLJ, page 497, has heard identical matter regarding crossing of 50% reservation.
Which one
This
is
is,
that?
this is I'm citing 2003, volume 4 MPLJ, page 497. This is Mayank Jain versus State of Madhya Pradesh, Justice Kumar Rajaratnam and Justice Deepak Mishra, my lord. Here the rule has been declared as ultra virus, wherein my lords have said it that 50% cannot be the limit. My lord, para 5 of this judgment I would like to read. Para 5 is at page number 499, Mayank Jain versus State of MP. First, I would like to read para 4, my lord. A return has been filed by respondent 1 and 3, contending inter alia that the rule in question is in consonance with the decision of the apex court rendered in the case of Indira Sahni versus Union of India and others, 1993 Supreme Court 477, to the effect that if reserved category candidate gets selected and so and so, so and so. Now, para 5 is important, my lord. Mr. Aditya Sanghi, learned counsel for the petitioner, has submitted that Rule 9.3 has indirectly accentuated the percentage of reservation and has created a class dichotomy which is impermissible if tested in the bedrock of the constitutional provisions in the philosophy of reservation. The learned counsel has submitted that the reservation in this manner is not allowed if the ratio of the decision in the case of Indira Sahni is appreciated and understood in proper perspective. Learned counsel has further propounded that when the Rule 5 of 2000 rules prescribes specific quota for reserve category, and then it continues, my lord, and finally, the my lords have said it in last paragraph, we declare it to be ultra virus. So our High Court has already considered this point vis-a-vis Indira Sahni. Definitely, as far as Maratha reservation is concerned, it came in 2021 only. So Maratha reservation covers everything according to me vis-a-vis the Honorable Supreme Court is concerned. Now, my lord, coming to Maratha reservation, my lord. My lord, I am reading Maratha reservation judgment from page number 194. It starts from page 1, but without wasting my lord's time, I have covered each and everything in my written submissions also, my lord, and the synopsis. But I would like to read only few paragraphs so that I should not take much time of my lords. So page 194, para 316, my lord.
In Maratha reservation.
In Maratha, my lord. That is Jayashree Lakshman Rao Patil versus State of Maharashtra. And the brief facts in the case is, my lord, that
316.
my lord, 316.1, page 194.
Oh, yes.
The brief facts are, my lord, as far as Maratha reservation, my lords know it very well, that the population of Maratha in the state of Maharashtra was touching 80%. And therefore, when the matter traveled to the Bombay High Court, the Bombay High Court upheld that particular reservation, that even if it crosses 50%, it's upheld. Then the matter traveled
No,
to the
there the enhancement was for which category?
for the Maratha people, my lord.
So
For,
that is,
pardon, my lord?
that is which category?
The Maratha caste, that is OBC.
OBC.
That is OBC.
Okay.
Exactly the same matter. So when the matter traveled to the Honorable Supreme Court heard the matter and declared that no, as far as the Bombay judgment is concerned, it is bad in law, and we declare that this particular judgment holds that 50% cannot cross. And Indira Sahni's judgment is absolutely verbatim they have quoted. My lord, para 316, I would like to read. 194. I'll be very, very brief, my lord. I know the, because there are a few other friends of mine who will be addressing my lords. So I'll be very, very brief. But this particular judgment holds everything according to my submissions, my lord, according to my knowledge. It covers each and everything, whether the population ratio, whether any other thing quantified data or exceptional circumstances as has been defined in para 810 and 8111 of Indira Sahni. So para 316 onwards, I would like to read. We may now notice the grounds which has been emphasized by Shri Mukul Rohtgi for referring the judgment of Indira Sahni to a larger bench. Page 194, my lord. My lords have got it, no?
Yes.
the 10 grounds urged for referring Indira Sahni's judgment to a larger bench is as follows. 316.1. In the judgment of Indira Sahni, there is a unanimity in view of different reasoning adopted in 6 separate judgments delivered in the case. He submits that the judgments are of 3 groups. One containing the judgment of Justice BP Jeevan Reddy, which is for himself and 3 other judges, which held that 50% is the rule, but in certain extraordinary situations, it may be breached. Shri Rohtgi submits that Pandian J and Sawant J have held that 50% can be breached. Hence, the majority opinion is that 50% can be breached. It is only Thoman J, Kuldeep J, and Sahai J who have held that 50% cannot be breached. He submits that the judgment of majority opinion in Indira Sahni is being wrongly read as holding that 50% is a ceiling limit for reservation. Now, my lord, I am skipping for the time all these paragraphs, my lord, and coming directly to what my lords have concluded regarding this particular ground. This I am coming, my lord. Now, my lord, I am coming to para 445, ground number 10, page 236.
445.
Ground number 10, 445.
Yes.
Shri Rohtgi submits that in para 810 of the judgment of Indira Sahni, certain extraordinary circumstances have been referred to which cannot be said to be cast in stone. The extraordinary circumstances provided in para 810, that is, of far-flung and remote area, cannot be the cast in stone and forever unchanging. He submits that the same was given only by way of example and cannot be considered exhaustive. Moreover, it is geographical test which may apply in every state. In para 810 of Indira Sahni, Justice BP Jeevan Reddy provided 810. While 50% shall be the rule, it is necessary not to put off consideration certain extraordinary situations inherent in the great diversity of this country and the people. It might happen that in far-flung and remote areas, the population inhabiting those areas might, on account of their being put on the mainstream of national life and on view of the conditions peculiar to characteristic to them, need to be treated in a different way. Some relaxation in this strict rule may become imperative. In doing so, extreme caution is to be exercised and a special case made out. We fully endorse the submissions of Shri Rohtgi that extraordinary situations indicated in para 810 were only illustrative and cannot be said to be exhaustive. We, however, do not agree with Mr. Rohtgi that para 810 provided only a geographical test, because this is the main ground of the reply of the state, my lord, in my matters.
Where did you read this?
Pardon, my lord? Para 446, my lord?
What is that?
Para 446. I'm extremely sorry, my lord, if I have read it without showing the para 446. We, however, do not agree with Mr. Rohtgi that para 810 provided only a geographical test. The use of expression on being out of the mainstream of national life is a social test, which also needs to be fulfilled for a case to be covered by exception. Then, my lords, have again, I would like to script this and comes to para 451, my lord, page 239, just the next page. Here, my lords have said it, that Indira Sahni need not be revisited. So, on this ground, at page 239, para 451, my lords have said it, in view of the foregoing discussions, we do not find any substance in the grounds raised by Shri Mukul Rohtgi for revisiting the judgment of Indira Sahni and referring the judgment of Indira Sahni to a larger bench. So here, my lords have concluded that Indira Sahni holds good. Now comes, my lord, the relevant portions which I would like to read vis-a-vis my matter, which covers the quantifiable data and again the exceptional circumstances, which is at the next page, page 241. para 457 onwards. These are very crucial paragraphs, my lord. I have described it in my written synopsis also, my lord. Para 457, my lord. What was said by the Constitution Bench in Indira Sahni clearly binds us. My lords have got it, my lord?
Yes.
The judgment of Indira Sahni has stood the test of time and has never been doubted. On the clear principle of stare decisis, the judgment of Indira Sahni neither need to be revisited nor referred to a larger bench of this court. The principle laid down in Keshava Mills, which applied to the facts of the present case, is crystal clear that no case is made out to refer the case of Indira Sahni to a larger bench. Now, my lord, comes the data available by the Gaikwad Commission, which was relied very heavily by the Bombay High Court. So, my lords have said it, whether the Gaikwad Commission report has made out a case of extraordinary situation for grant of specific reservation in Maratha community exceeding 50% limit. We have noticed that the majority judgment in Indira Sahni has laid down that reservation shall not exceed 50% as a rule. In the majority opinion, however, it was held that looking to the diversity of the country, there may be some extraordinary situations where reservations in exceptional cases made exceeding 50% limit. In this respect, we may again refer to para 809 and 810 of the judgment of Indira Sahni, by which the above proposition of law was laid down. Para 809 and 810 are the following effects. My lord, I am skipping this because I have already read this particular this paragraph. Now comes para 460. The second term of reference to the State Backward Classes Commission included a specific reference, that is, to define exceptional circumstances and extraordinary situations to be applied for the benefit of reservation in the present context. The Gaikwad Commission has separately and elaborately considered the above term of reference. A separate chapter 10 has been devoted in the Commission's report, the heading Exceptional Circumstances or Extraordinary Situations. We have already noticed the submissions of Shri Mukul Rodgi with reference to the exceptional circumstances while considering ground 10, or as emphasized by him for referring the case to a larger bench. We have observed that the exceptional circumstances as indicated in para 8110 or Indira Sahni were not exhaustive, not illustrative. The Constitution Bench, however, has given indication of what could be the extraordinary circumstances for exceeding the limit of 50%. The Commission has noticed the majority opinion in Indira Sahni. We may notice para 234, chapter 10 of the report, which is the following. My lord, this I would like to skip. Then I am coming, my lord, to para 462. That is the next page, 243. After noticing, para 462, my lord, after noticing the above proposition of law, the Commission proceeded to detail with the subject. In para 234, the Commission has noted the Constitutional Bench judgment in M. Nagaraj versus Union of India, observing that this court has again considered the aspect of ceiling of 50% reservation. The Commission, however, proceeded with an assumption that in Nagaraj, this court has ruled that for relaxation 50%, there should be quantifiable and contemporary data. We may notice the exact words of the Commission in para 234, which is of the following effect. The Honorable Supreme Court, I quote, my lord, the Honorable Supreme Court has again considered this aspect of ceiling of 50% reservation in its next decision in M. Nagaraj versus Union of India, wherein the Honorable Supreme Court considered the validity of inserted clauses by way of an amendment to Article 16 of the Constitution. However, in Nagaraj, the Honorable Supreme Court has ruled that for relaxation, that is ceiling of 50%, there should be a quantifiable and contemporary data. The above view has again been reiterated by the Commission in para 235. 235 quotes. However, it is seen from Nagaraj that ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to backwardness as required by clause 4 of Article 15 and clause 4 of Article 16. From the above, it is clear that Commission read the Constitution Bench judgment of this court in Nagaraj, laying down that ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to the backwardness. The above reading of the Constitution bench judgment by the Commission was wholly incorrect. We may notice the judgment of M. Nagaraj in the above respect. M. Nagaraj was clear where the Constitution 85th Amendment 2001 inserting Article 16(4)(a) was challenged on the ground that so and so. Now, my lord, para 465. The Constitution bench proceeded to consider the submissions raised by the petitioner challenging the constitutional validity of the Constitution. My lord, I am skipping